swear in Representative Administration. If you will come up, please, sir. You've done this so many times before. So if you will raise your hand, please. And at the end, you can say, I do or I will. Do solemnly swear or affirm that I will discharge all the duties lawfully required of me as a member of the Georgia Child Support Commission to the best of my ability and understanding. I do further solemnly swear or affirm that I am not the holder of any unaccounted for public money due to the state or any political subdivision or authority thereof, that I am not the holder of any office of trust under the government of the United States, any other state or any foreign state, which I am prohibited from holding by the laws of the state of Georgia, that I am otherwise qualified to hold said office according to the Constitution of the United States, the laws of Georgia, and I will support the Constitution of the United States and of this state.
I will.
Thank you, sir. Welcome aboard.
Thank you.
Appreciate you, sir.
Yeah, thank you very much.
You will swear.
And I'll sign this right here.
And Elaine will notarize. Business. Thank you.
Good, thank you.
All right. And you're welcome to be thinking about which committee on which you would like to serve.
Yes,
Let's put you to work. Oh, perfect. He's on it. All right. Regrettably, I'm going to recognize Justice Lagueux.
Thank you, Judge. Unfortunately, this will be, well, I don't know if this will be my last meeting or not. I am rolling off the commission. I had a conversation with the governor's office after session. I regret asking to roll off, but I don't feel like in my new position with some of my responsibilities, I've been able to give this body the attention it deserves from its members. And I don't think that's fair to, in particular, the children of this state. This is an incredible commission with the addition of Representative Strickland and Regina Quick's background and Judge Williford and Connell and Representative Gaines. And you've been on, I mean, you asked me to join 6 or 7 years ago. Y'all are in great hands. I know the governor's new appointee will be an excellent addition, and I will remain involved to any extent I can help the commission, and I will remain active at the meetings to the extent I can until there's a replacement. I just appreciate everybody's support and patience, especially Katie, in trying to teach me some of this as I came on and has been supportive over and Regina over the years, Judge Key. So thank you for this opportunity. And I really do regret leaving, in particular, the great people here. So thank you so much.
Any commission members or staff, anything to say?
Thank you, Lagueux. We certainly will miss you, but we hope you'll continue to support our efforts. I know you will.
Absolutely.
I've already talked to you.
Yeah. Thank you so much.
Justice has been an amazing member of this commission. We're going to miss you personally and professionally. It's kind of hard to do it once, and that's hard to do it the second time, because when you took the Supreme Court position, you left us and you came back. And we wish you well in your continued service in this state.
Please call on me as I can be of assistance. No, seriously.
You know, we will.
Okay.
And we'll work you through that. Connie, would you give us our house rules, please?
Yes, Judge, and hopefully everyone can hear me. I'm kind of in the corner. Good morning, everyone. I am Lagueux-Alvarez, and I am the program coordinator for the Child Support Commission. I will briefly discuss the rules and how to navigate the meeting today. Yes, in the webinar. Child Support Commission meeting members and staff are designated by panelists within Zoom and can speak at any time during the meeting. All other participants are designated as attendees and are muted during the meeting, but may take a message in the Zoom chat feature. Anyone wishing to give public comment by speaking today may do so at the end of the meeting after the conclusion of our agenda. Please state you would like to give public comments by typing your name or typing your request in the chat. Once you are called upon, to go unmute your audio. Our chair, the team will make determination of how many minutes you are about to speak. Turn that back over.
Thank you. The next order of business is review and approval of the minutes. The minutes from our last meeting of November 4th, 2022 have been distributed to all the commission members. Hope you've had an opportunity to review them. Are there any corrections? Give people time to unmute if you're virtual and trying to say something. If there are no corrections, the minutes are approved as distributed. Next,
Judge, may I put on the record that we have a firm of 8 members?
oh,
in
yes,
a combination of in-person and on-Zoom.
thank you. I was supposed to do that before I call for the vote, but thank you, Noelle. Next order of business, we get to the business, the commission subcommittee reports. Dr. Tutterow from Economic Subcommittee.
His speech starts in 15 minutes. Okay. Dr. Tutterow, are you still with us?
Looks like we just lost him.
I was afraid of that. He says he has to sign off in 4 minutes. That was at 10:13. So he may have already. Oh, and we have Christina Scott, member who has joined us.
Was Ms. Scott present for the vote? Because I'm not sure that Roger was.
Roger was.
Roger
he
was
dropped off like.
right after. Okay, so we're okay there.
All right, welcome, Christina. Would you introduce yourself, Christina?
Yes, good morning. I'm Christina Scott, a member of the commission.
And your day job is?
Oh, I'm sorry. Yes, I am a full-time mediator doing mainly domestic and civil mediation.
So I've already talked about how amazing our staff is. So does anyone care to jump in and maybe talk about what Dr. Tutterow might have reported on?
Yeah.
Thank you, sir.
Sure. Okay, so the subcommittee last met on Wednesday, October 18th, and approved the final draft report that was prepared for the commission by Dr. Jane Benor of the Center for Policy Research. She did the pure economic study that's required every 4 years. In that report, Dr. Benor proposed various updated BCSA tables, and the economic subcommittee has taken those under advisement and will be holding a meeting shortly. I think that just got set for mid.
June 21st, I think.
Yeah, late June, to discuss the various options for updating the BCSO tables going forward, which will ultimately, of course, need to be included in legislation and approved by the General Assembly. So Dr. Tutterow anticipates further discussion about Dr. Benor's suggested tables. It'll be discussed at the subcommittee level in June and then at the full commission meeting in August. And the staff has compiled, mostly Elaine, I should say, a final report that was placed on the commission website. It's under the Business of the Commission page where you will find the 2022 economic study. And that was distributed in January to the governor, to all members of the Georgia General Assembly, to the Division of Child Support Services, and then also as required to the Federal Office of Child Support Enforcement. It was also further distributed to the Council of Superior Court Judges, the Council of Juvenile Court Judges, and the Council of Magistrate Court Judges, because we felt like those judges routinely hear matters involving child support. So the outcomes from the case sampling component of the economic study are informative and important for future meetings, and staff, Elaine, right now will provide some details on what we gleaned from the case sampling data.
And while Elaine is setting up, have we received comment, questions, feedback from the report, from the final report?
We got one very pleasant comment from Superior Court Judge Darasaw, Victoria Darasaw, down in Doherty County, and she just thanked us for it. And so, so we know they have received it with us. It's good news, yeah. But no substantive comments.
There's so much work that went into that, both by our committee and our staff, and a shout out to our Superior Court clerks around the state too. They took a lot of time preparing and providing information to us for that report.
Absolutely.
Elaine, when you're ready.
Answer in the stage. Yeah. Okay, good. Okay, so I'm going to take you through this as quickly as possible, but also making sure that we help you understand those outcomes that we found. The staff is, and the commission is required every 4 years to make sure that we do an economic study of our child support guidelines. And that's a CFR requirement that I have up there on the screen that includes case sampling. So what is case sampling? It's us looking at orders and worksheets, making comparisons. We know how to read them so that we understand what is supposed to be in an order and what is supposed to be in the worksheet that is carried to the order. So Dr. Tutterow, who unfortunately could not remain on the call with us, he is our chair of the economic subcommittee. And he created an algorithm. Now, we've been using that algorithm since 2006, and he's amended it a little bit over time. But it's representative of Georgia geographically and financially so that we can select the counties that are appropriate for the study. We started out this time, and this was in the beginning of 2022. We began, looking at 15 counties and then quickly realized we needed to add a metro Atlanta county. So we added Clayton County to that mix. And we had to gather orders from the 16 counties for the case sampling. The 16 counties were those that you see on the screen: Appling, Clayton, Early, Eccles, Elbert, Fannin, Fayette, Forsyth, Glasscock, Glenn, Houston, Paulding, Rockdale, Stewart, Troop, and Ware. And we had great cooperation from the clerks regarding the gathering of the data that we needed. So what did we end up with? We ended up with 472 worksheets and orders. And of that, the private cases, there were 277, and that could be a private attorney or self-represented litigant. We also had from the Division of Child Support Services 195 cases. So we went to those clerks, we have a little letter writing, communicating with them. Would you please gather this for us? There were 2 or 3 of them who we traveled to their counties. We're welcome, we welcome that. If they can't help us, if they're short on staffing, we jump in the car and we go visit them for a day or 2 and gather what we need. And it's an adventure, isn't it, Latona, to go through and gather all that data. And we enjoyed that opportunity. So with all that gathered together, we put it in a gigantic spreadsheet with all this data. So then we started looking at what did we learn? Because this is what one of the things we're charged with doing in the commission is making sure that we're providing training for the public, for attorneys, judges, anyone who's using the child support calculator. So in Georgia, we have one child support calculator. We have the website up there for you. That's the direct link to it. And we discontinued the Excel child support calculator in October of 2018. However, most unfortunately, we still have people utilizing the Excel child support calculator. And I have a list there of the various versions that we found as we went through reviewing the worksheets. And it always troubles me when this happens because some of these worksheets did not include the current low-income deviation, how that's applied in the statute. We found 27 worksheets that were Excel, and of that, 9 of them were prepared by self-represented litigants. I always have to wonder, where did you get that worksheet? But because the online is available, 24/7. And out of those 9, 3 of them were handwritten. So right off the bat, that they didn't understand how to go to the table. The calculations were not correct by the time they got to the end, and they literally would just put a number at the end as to what they wanted that child support to be. Then we had 18 worksheets that were Excel that were prepared by lawyers. We will be talking to those attorneys, offering training, offering assistance, answering questions, whatever they might need to help them move forward and into the modern age of our online child support calculator. Okay, so we're going to look at issues now and make sure that you are aware of what we found. All right, so RSDI, your Retirement Survivors Disability Insurance. This is one of the things that in our statute, the non-custodial parent, if that parent is disabled, can apply the amount of money that's being paid to the children, and it gets applied in the worksheet against the child support obligation. And I have the code section signed there for you. What we found is that there were worksheets and orders where this credit was not extended. We would see the information in the order, but not in the worksheet. So this is how we know that we had an issue there. It was either not extended to the non-custodial parent, or it was extended in error to the custodial parent, which doesn't impact the child support as it appropriately should. So we had 5 instances of those types of issues. The order was entered, but no worksheet and or the completed schedules were filed with the clerk. We had 7 instances where they were not filed. On occasion, during the time that we were evaluating the worksheets and orders, I pick up the phone or send an email to an attorney and say, you represented so-and-so, and we can't find that worksheet in the clerk's office. And a day or two later, it would get emailed to me and it would reflect a clerk's filing stamp of a day or two earlier. So at least they filed it at that point. That's a training issue. You're going to find that a lot of the issues that we have in here are for training, and some of them are simply proofreading. Okay, multiple children step down. This is in subsection B12 of the statute, where we allow people, if there's an event occurring where a child's going to age out of the order within 2 years of when that order is being entered today, there can be a multiple worksheet situation. 2 kids in the first worksheet, 1 child in the second worksheet, and it helps the parents not have to go back to court within that 2-year period to modify, when they do have children aging out. So we found that there were instances where the children were very young and there was not an event occurring within the 2 years. Health insurance cost was not then corrected in the second worksheet when you had a child aging out. Same thing with like a pre-existing order. These are just a few examples, but we had 45 issues of mistakes that were made in this type of situation. Okay, let's see.
Those, do you have any sense of how many of those were self-represented litigants versus represented?
We do, and well,
Generically, I'm not.
I really don't have it to that level at this moment. But that is something that we could get for you. Noelle, can you make a note?
I only raise it from the training perspective. It's easy for Judge Williford and Katie and Regina and all to do training for attorneys. I just don't know the answer to the training for self-represented, if that's where a big chunk of it is.
Well, and I'm glad you brought that up. We do provide on the Child Support Commission's website under training. We have a training for self-represented litigants, parents, and it's 8 modules. They're video, and they get to hear Noelle and I talk, and we go through the process of how do you set up a user account, all the way through the worksheet, making sure that they know how to enter income in every field on Schedule A, Schedule B, Schedule D, and to Schedule E with deviations, which is our longest of those videos. And then making sure they understand, how do I get back into my worksheet once I've closed it out? How do I go back into it? How do I print it? So we have some very basic information there. We actually wrote a script for it with help from, specifically an attorney in our office who works with a lot of self-represented litigants, and made sure we had the language, in a place where they would feel comfortable with what they were hearing. So we do have that training on the website. We also provide on a monthly basis online training that we provide through Zoom, the 3 of us, Latana, Noelle, and myself. And that's an hour of live. It's interactive. We do Q&A at the end of it. As far as the self-represented litigants, we do receive phone calls for them. I talk to a good many people on a weekly basis, and it's limited as to what we can answer for them sometimes because of some of their questions are legal. So we direct them to the training information. And our questions also will stem into income deduction, which I'll cover a little bit on in a moment. But when we looked at the uninsured, which is that percentage at the very bottom of the worksheet, we had 109 instances where the uninsured was either not entered in the worksheet, it was 0. It was not in the worksheet and the order, it was missing from both, or they were different percentage amounts. So again, training.
Elaine, if y'all are going back, excuse me for just a second, if y'all are going back and looking at those for a breakdown, if you could highlight for me and let me know about the DCSS errors, I would appreciate it, unless y'all have already notified the division.
We have not, but that is one of the things that we wanted to do, was to meet with them and talk about it. There will be a couple of things we'll cover in this PowerPoint that you'll see that focus in on low income deviation in particular is one of them. Okay, so we had worksheets where the worksheet in order, the non-custodial parent was not the same or was not selected. Sometimes they indicate the custodial parent as the non-custodial parent. I see that as a big proofreading issue. You just have to go back and look at your documents, make sure they're correct. The child support amount in the worksheet in order was not the same, and we had 18 instances from the worksheet to the order. They were not the same. Thank goodness those cases don't get appealed. Non-parent custodian name was excluded from the worksheet, but included in the order. And that's something that when the judge is hearing the case, we know the judge wants to know that type of information to be fully aware of who's involved in this case. And then we had the number of children in the worksheet in order that were not the same. We had 3 instances, not terribly egregious, but if you have 2 children in the worksheet and 3 children in the order or vice versa, that changes the dynamic of the child support because the number of children has to be correct for the table to bring over the correct basic child support obligation. Okay, this one is very concerning. It's always been one I've seen every time we've done one of these studies. My first one was 2006. The effective date for the first payment of the child support is not included in the order. So when is the non-custodial parent supposed to be aware, when do I start my first payment? So we had 24 instances of that. The style of the case, we had issues where the civil action case number was left off the worksheet, or it was a little different from worksheet to order. Name mismatches. We always tell people in training, make sure your pleadings and your worksheet match where the names are concerned. So there's no discrepancy. We had 55 issues of that. Those types of mistakes. This one to me is one of the most egregious. I've talked to Noelle about it. It really troubles me. Children named only in the worksheet, never named in the order. They're not in the order at all. There were 23 instances. So this is where I want to pick up the phone and talk to the attorney and say, please, please in the future, include the names of the children and their year of birth in the order. All right, so sometimes we had just 6 instances, but orders that were per child, and our statute doesn't provide for per child, it provides for a group order amount. And, oh, thank you so much. I forgot to bring my water with me.
We work so closely that I read your mind.
She knows me like a book. Okay, so now we're going to move to Schedule A. The Uniform Superior Court Rule 24.2A, which is our multiplier rule, was not applied when converting weekly and hourly wages to monthly amounts. We had 12-ish instances. The nice thing is in the calculator on Schedule A for each field where income is entered, we provide a mechanism for converting those numbers based on the rule. So you can't get it wrong if you use that multiplier that's built in to the calculator. And we train people on how to use that. So obviously we have more training to do. Imputed income was entered in the worksheet when in the order, it reflected that there was earned income and the incomes didn't match each other. So it creates a conflict. What does it also do? It creates a conflict in the BCSO that was used in the calculation. We only had 1 instance, which when I was telling Noelle about this, she goes, wow, that's great. From 2014 to 2018, in those 2 studies, we had a higher number of those instances. This time we only had the 1. I hope that means that people are becoming more and more aware of making sure that what's in their order and worksheet matches. Imputed income not explained, we had 30 instances. Now, this is not a requirement in the statute, but we train to include an explanation of the imputed income for 2 reasons. The judge needs to see it, and you need to see it 6 months from now. How did I come up with that amount of money that I put in there for imputed? Because you have a lot of cases, or maybe it's just your only case because you're a pro se, but at the same time you want to remember, how did I come up with those numbers? Income of parents, income of a parents from gross income and salary was wrong or missing in the worksheet in order, meaning again, conflicting information. This is where line 19 of Schedule A, they're putting in their gross income, but it's missing in the order. They didn't put it in the orders they're required to do, or the amounts don't match. All right, so let's talk about Schedule B. The one thing we did not see in this particular case sampling was that there was no example of the self-employment taxes paid included in any of the worksheets. So there were no points of failure there. There were just, nobody entered any as an adjustment to gross income. But pre-existing orders, yes. And this is not uncommon for pre-existing and for qualified. The entry of the data, they're just simply not putting in like the child's full name, or they're not putting in, they're putting the full date of birth rather than just the year, things of that instance, they don't pull out the pre-existing order information in that step-down worksheet. They don't write an explanation. When you get to the qualified child for a theoretical child support order, that's the only place outside of Schedule E where there's discretion. So the judge has the ability to say, I want to include that, or I don't want to include that. And a written explanation is necessary so the judge can read that information. So we need to work on obviously helping people understand, do a better job of entering the information on Schedule B. We had 27 instances. Some of this also included that the schedule was simply not filed in the clerk's office. One of the things that we worked on painstakingly when we were designing the online calculator is that they can hear me, right? Because this little drop down just came down and said I was muted. But out there in TV land, okay, thank you, Katie. It's the overhead that's working into my advantage. So it's surprising because the form is designed so that you file the worksheet and all the schedules. And we reduce the number of pages that print and so forth from what we had with Excel. And so it does surprise us when the entire worksheet is not filed in the clerk's office. So that again is a training issue. For Schedule D, this is where we have those additional expenses of health insurance and work-related childcare. This was one of the most disappointing areas because there's a federal requirement that we include health insurance coverage in these child support worksheets. And the cost that's actually being paid was missing from the schedule, or there was a conflicting amount between the schedule and the order. And the conflict also on who was paying that expense. Sometimes we couldn't figure out for certain which parent was paying. And sometimes that's plaintiff and defendant are mixed up within the order itself, and we just couldn't discern who was paying the cost. Another one was Peach Care. Peach Care premiums can be included. They're a form of insurance and there's a premium involved, even if it's minimal. That can be included and was not. We would see mention of it in the order, but we wouldn't see a premium included. So we had 201 instances. That was the most egregious of any mistakes. And
Could you remind folks how many cases we're talking about?
yeah, 472 cases.
So
201 out of that 472. Yeah, we had issues. This is historically every study we have done. This is the one area where we fail the most is in the health insurance. I know from having done casework with the Division of Child Support Services many, many years ago that the non-custodial parent won't come in with any of what the discovery requires, and you don't have this information, or parents simply don't have the information, or they simply can't afford health insurance. So there are barriers to this, and this is going to need some continued discussion. Okay, work-related childcare, Schedule D. The schedule was not filed with the clerk. Again, we saw that with Schedule B as well. We had 5 instances of that. And sometimes it's also making sure the information that's entered is accurate. Okay, for Schedule E, the first thing we're going to talk about is findings of fact. This is questions B, C, and D, where we have to make sure that those questions are answered. And they were either not answered, or they were not sufficient answers, or the answers were contrary to what was written in the order. Sometimes there was information on findings written in the order, which was not in the worksheet itself. And we have instances where the findings of fact were answered as yes, no, or in the best interest of the child. I know we have at least one case out there that says, no, you can't just do that. You have to answer why this deviation is appropriate for this case. So we had 57 instances of issues of this nature with findings of fact. And other deviation issues, typically it was the worksheet and order simply not agreeing. There was a conflict in the information. Some of this might also be that there were instances of people putting the information in the worksheet, but not putting, they're not including any findings of fact about that deviation that's included just in the worksheet. They also would indicate, we had 17 instances of issues with deviations. Worksheet included a low income deviation to reduce the child support, but there was no low income deviation in the worksheet. So we saw some of that type of issue. Okay, so let's talk about low income in more detail, because we found that there was a really low usage of the low income deviation. We had 472 total cases. We had 11 out of 472 that used a low income deviation. 2 of those were simply trying to reduce the child support, because I pulled back out the documents and looked at the documents to make sure, were they really trying to do a low income deviation? But these were incomes that were higher. And I think they just stumbled onto the low income deviation and used the wrong deviation. So we have concerns that the lid was not utilized when the income of the NCP was low, which might mean the parent was experiencing an extreme economic hardship, which is what the statute describes, and may have difficulty paying the child support. So here are some of the numbers that we came up with. So we looked at income for the non-custodial parent at or below $1261.50. Now that's the monthly minimum wage pursuant to the Uniform Superior Court Rule 24.2a. We found 91 cases that might have used a low income deviation because it fell into that income range or lower. 26 of those were private cases and 65 were DCSS cases. We also looked at income between $1261.50 and $1850, and you're probably thinking, why $1850? Judge Key will remember from many years ago when the statute was first passed effective January 1 of 2007, we initially had a self-support reserve, and it set income at $1850 or less for the non-custodial parent to qualify for the low income deviation. September 1st of 2009, that calculation for low income was removed from the statute. We did a study in 2008 and came up with a different plan. And the goal was to open it up more to higher incomes than just $1850. Because remember, if you were at $1851, you didn't get the deviation. You only got it at $1850 or less. So the commission felt like it was limiting and they wanted to broaden this, but we haven't necessarily seen that to be the case, especially when you have true 9 deviations that were used during this study. So what we found when we went higher on the income from $1261.50 up to $1850 is that we had 41 more cases that we had income levels, and 14 of those were private and 27 were DCSS. All right, so we had 132 cases where the low income deviation was not included in the worksheet and the resulting order. All right, so again, we're going to talk about those total cases, and this is interesting outcomes from our case sampling, things that we thought, So the number of times income was imputed to the custodial parent was 141 times, and then imputed just at $7.25 an hour, 108. And then for the non-custodial parent, income was imputed 135 times. And when it was imputed just at $7.25 an hour, that was 102 cases. And we also found that we had 49 cases where the child support was reduced to 0 using a parenting time or a non-specific deviation to 0 the child support. Okay, now there were some things we did not see repeated, which is always good. From the 2018 case sampling, these were errors basically that can be cured if people would stop using the Excel child support calculator. And those that did, we thank them. Manual information entered, that seems to be an issue that occurs when you have an Excel calculator involved. The pounding question mark was the error that you got when the macros were not enabled in the Excel. And you would see that all through the worksheets, you would have no calculations. Deviations entered under incorrect parent for the specific and non-specific. That was something we were able to cure with the online calculator because we could direct where the entries needed to be made. We couldn't do that with Excel. Excel had limitations. And then pages from multiple worksheets being used. We saw that in years prior. We did not see any of these things occurring in this 2022 case sampling, which was wonderful. All right, let's talk about income deduction just a little bit. That's another little component of what staff does with the Child Support Commission. We work with the Division of Child Support Services on these cases because we're bridging that gap for the private bar and for individuals who are self-represented. And so we have a website dedicated to just income deduction in Georgia in private cases. And it's listed there on the website, on the slide rather. We found that the income deduction order, it was ordered, but no separate IPO was entered, which is what the statute requires. And then we also found people not using the only income deduction form that is allowed in Georgia under the Uniform Superior Court Rule 24.12. So we had 18 instances. We believe there were probably more instances where there was an intent to enter an income deduction order, but it was not entered. And I think there's just still misunderstanding. You can enter that income deduction order, file it in the clerk's office, and it might sit there 2 or 3 years before there's a job where it can be placed, and that's okay for it to sit there and wait. Okay, so there's our thank you. So if any of the members have specific questions, such as Regina and Justice Lagueux, we're glad to gather some more information for you and provide that. And want to say thank you for listening to this presentation. We just felt like it was important for you to see some of the outcomes that come from the requirement that Georgia looks at its guidelines. Okay, I'm going to stop sharing and then we can resume with
Any questions for Elaine?
Sorry. Thank you, Judge. Thank you. Any questions from the audience on Zoom?
I didn't really have questions, Elaine, but I'll just tell you that was very helpful and useful. I think that to a large extent, the Superior Court judges are the gatekeepers on that. Really looking at those before they're signed and making sure that they're correct and all of those things match. And Superior Court judges, I mean, their staff attorneys, if the staff attorneys were trained, and I don't know how to make that happen, but trained to look at these things very closely. And I think because I come from a family law background and I brought my associate attorney, who obviously was a family law associate, with me to the bench as my staff attorney, it makes it very helpful for us. But looking at those things, now I will say to Regina, I know that you know this, as a Superior Court judge, you just get stacks of these orders from Child Support Services and you just sign them. You know, the worksheets aren't attached, you just have to trust that Child Support Services did it right and you just sign the orders. I mean, sometimes I sign, 50 to 100 of them in a month, and sometimes more than that. But for the private cases and self-represented and the ones from the attorneys, we look at those things closely, not to say we don't miss anything, but as I was looking at your presentation, I saw things that maybe we're not looking at, that I didn't even consider. So I appreciate so much that presentation. I think it's very helpful. Judge Raymond in our circuit, every month he puts together a memo of all the family law cases that have been decided by the Court of Appeals or the Supreme Court of Georgia the month prior. And he sends it out to a group of Superior Court judges, not just in our circuit, but in several circuits. And you see, and Justice Lagueux certainly knows this, you see the same issues over and over and over again. And just simple things with the worksheets or not putting the reason for the deviation or things like that. But I think if we could get, training, and I know y'all are available to train, but just making people actually do, come to the training. And certainly with Zoom now, things could be done so easily that maybe we could help with some of these numbers. That seems like a lot of errors for 400 and something case sampling.
Noelle and I are working on a training for this very purpose that stems from these issues. And that's something that we routinely do after we finish one of these economic studies. And so we will begin providing some training on these items. And hopefully that's going to help out. For the judicial staff working for the judges, we have in the years past provided some periodic training that's been scattered through the years, but we're happy to provide, if you can help us find an avenue in to where they're meeting, like if they're doing some sort of annual event, we will show up and we will happily provide training to them. Noelle, yes, Justin.
There is a training done every year for staff attorneys at the state bar. I can help y'all find, and that might answer what Judge Williford's talking about.
Yes.
If we could get you on that agenda, it's a pretty full. Now, I assume they're doing some Zoom for around the state, but it's usually pretty well attended. I've been there before, and it's the full room at the state bar, the big
Right.
room, and it's for specifically, it is staff attorney training
Great. We would be happy to join.
for Superior Court.
And may I add, let me just say, the training is working when you guys focus on something, because one of the things that you just presented about was when the numbers don't match. Well, that was something we were talking about in training, a few years about needing the training on it a few years ago. And then in this economic study, we saw clear improvement. So I don't, lest we only focus on what still needs to be improved. And that list is always going to be, there and evolving, frankly. But, I was heartened to see just a minute ago, Elaine, in your presentation that, that you mentioned a few things that in years past, we've been saying, oh, why can't we get this right? And and the numbers matching is a perfect example. And I thought to myself, as you were presenting, well, yeah, because, what we know about Superior Court judges, and no offense to any of you here or any of you who have been there and moved on, but, what we know is that they don't like to get overturned, especially on silly things. So approaching them with hey, we're going to save you a little headache. We're going to save your ego a little bit, and then telling their staff attorneys, hey, how many times have your judges said to you, hey, don't get me overturned? So if we approach them, with that, it works. So we know that because this economic study actually, as much as we have now identified, either new things or things we need to continue to focus on, you also showed us some things that, just a few years ago, we were seeing a lot of issues with, and we've seen improvement. So I want to say kudos to y'all for that, because I made a mental note as you were presenting on a couple of things that I know that y'all focused on, and then the evidence just bore out that there was improvement there. So thank y'all for that.
And one of the biggest and easiest things to do is proofread. And that's when we were going through orders, I'm like, oh my gosh, if they had just proofread, they wouldn't proofread the document, they wouldn't have swapped that piece of information. So a lot of it is proofreading. And I know that gets boring for us because we do it all the time.
Well, and none of us is perfect. Everybody, you can have a great day of proofreading, and then you can have a bad day of proofreading.
Exactly.
I would like to comment that you mentioned, Elaine, and I think this is just worthwhile for the commission to keep on our radar. You mentioned that you train for an explanation to be included when income is imputed, but you also mentioned correctly, of course, that the statute doesn't require it. Let me say, in my experience, and I understand I can't possibly be a representative for all child support cases across the state, but I do this day in and day out. I find a little bit of hesitation on my Superior Court judge's part when we are, especially if we've had to go have a hearing on the issue or a trial on the issue of imputing income to one or both of the parents. One less thing to have to include, almost like the findings of fact, leaves them with one less thing to feel like they might get appealed on it. So I wonder if, while I don't doubt that y'all are training to include the explanation for the imputed income, and I understand the logic of that, and you gave a couple of good reasons there in the presentation why it should be done. I will say, when I've had to deal with that in the courtroom, where a judge has had to make that decision, you can almost just see the hesitation of, hey, if I'm not required to include this, I'm not going to. And I genuinely am not saying that as a laziness thing. I'm saying I just think it's one less issue to create potential fodder for an appeal. So that just something to keep in mind on that particular issue.
Thank you. Thank you for sharing that.
So thank you, Elaine, and all the staff who worked on this, and thanks to our commission members for that. A really good discussion. around this. All right, let's move next to Statute Review Committee, Katie and Judge Williford.
Go ahead, Katie.
All right. Sorry, let me scroll to that part of my agenda here. All right, so the Statute Review Committee continues to be a very active committee. We are now, thanks to Judge Williford's attention to detail and foresight, we are now scheduling not just one meeting ahead, but 2, 3, 4 meetings ahead. And we sincerely appreciate staff for helping us with that. In some ways, that's a little extra work for them, but at the same time, it allows us to meet regularly and publish our meetings well in advance to allow our committee members to plan to be there. So we thank everybody for that. We have been working with Dr. Benor. Hopefully everybody's familiar with who that is. For you new commission members, I guess I shouldn't assume you do. She is the economist that Georgia has hired repeatedly over the years to do things like the economic study that Elaine just reported on, but also right now she's helping the Statute Review Committee with a contract to address both the low income deviation issues that Judge Palmer has been working on, and the parenting time deviation questions that I have worked on, and now Judge Williford has sort of taken the lead on that now that that study committee is complete. Judge Venora is with the Center for Policy Research, so hopefully everybody's familiar with her. The subcommittee approved a survey that went live on the commission website on March the 12th. I know that people have been doing it. I've actually gotten a couple of emails and text messages from colleagues and friends saying, hey, I got this survey. Is this something you want me to complete? So naturally I write back and say, yes, do complete that. So that survey is out there. The calculator homepage, let's see, and emails have been sent out. This is all related to the survey. Sorry, I'm reading my notes here. So hopefully if you haven't seen that survey, you will look for that. We encourage commission members to share the link of the survey. It's at the top center of the commission's website with your own contacts. So if you know anyone, Christina is a great example, deals with a lot of family law practitioners. Obviously, Representative Estration would be a good one too, if you wouldn't mind checking that out for us. We're just trying to gather as much information as we can. It is a public survey, and we want as many responses as possible. Oh, look, and Elaine's given us some stats here. So I'll let you tell us about those, Elaine, in just a second. So we will continue to spread the news on this survey. The more responses we have, the more helpful it is. DCSS issued an alert notification on their website and added some social media posts in their weekly report. So we're definitely trying to cover all our bases, not just private practice. And distributions have included the Superior, Juvenile, and Magistrate Court judges through their respective councils and parent organizations. There have also been some email blasts sent by the State Bar's Family Law section. I suspect that's where, when that blast goes out, is when I get the emails that ask if it should be completed. So right now we have received 879 survey responses. That was through through April 15th. So I'm going to hand it over to LaTonna in a minute to tell you about the details. But we are just continuing to gather information, meet regularly, and discuss the issues before the Statute Review Committee. Our next meeting is scheduled for May the 19th at 2 p.m. And then we have another one scheduled for June the 23rd. Both are at, that one's at 10 a.m. and both are by Zoom because we do have people from across the state. So LaTonna, I think I'm turning it over to you to tell us about the 800 and almost 880 results we have so far from the survey.
Yes, Katie, thank you.
Sure.
Yes, the survey, well, I have a graph that I created and I just put it up on the screen so everyone can see. But like Katie said, there are 879 survey responses as of April 15th. And majority did vote to keep the terms the same for the custodial, non-custodial parents at 497 total, you can see. And then just kind of going down from there, we have 140 that voted for primary parent or secondary parent. Next, we have 76 for receiver or payor. And then we have 70 who voted for payee, payor. 51 voted for Lagueux-Alvarez, and 45 voted for greater time parent and lesser time parent. Our results. And who was going to turn it over to? Now we turn it over to Regina.
So Regina, Chair, I think I'll back to this.
And Judge Key, the subcommittee spent a little time around the holidays with staff and one another, just reviewing how the commission's decision about archiving, allowing the deletion and archive of the shared and expired worksheets was going. It seemed to be going very well, and have not heard of any problems associated with that change made by the commission. We've been discussing and keeping apprised of calculator maintenance, and continuing to just discuss, is there a way to simplify the calculator itself so that more people can understand how to utilize the low income deviation? No silver bullet has emerged from those discussions about, hate to keep talking about training, but we do keep talking about the fact that some of it is just a matter of understanding the worksheet and how it operates, but we're continuing to discuss that. As well as the pre-existing order question, which is fraught with problems for judges who have to rely on lack of the best documentation and the best evidence of whether or not there is compliance with all the elements necessary to get credit for that pre-existing order. So no answers on that one yet, but we will continue to consider that and examine it and discuss with staff. No meeting scheduled yet to come back together and talk about that, but those are the items that are on our radar. So if anybody has any solutions or great ideas that you would like the subcommittee to look at on the low income deviation issue or the pre-existing order issues for how the calculator functions, just get in touch with me.
Thank you, Jay. You have any questions for Regina or comments? I certainly don't know how to make the low income deviation any easier to use, but I've been using it for a considerable period of time in the juvenile court. I was a divorce lawyer 6.5 years ago when I went full time. And almost all of those that I do in juvenile court, certainly for the custodial parent, are either reunification deviation or low income deviation. So as an experienced user, it's hard to say how to make it easier, but it looks pretty easy to me. I don't have any ideas. And of course, I attended the training from staff at the Children's Summit last fall as well. All right, thank you, Regina. Okay, Noelle, this is an information item, not an action item. You report. Next,
Yes.
please.
Yes, you may recall I spoke extensively at the December meeting about publicly posting our recordings of our meetings, of which are recorded through Zoom. That's primarily just to jog everybody's memory, because with the flip to Zoom in the pandemic, we suddenly had this surge in the public requesting copies of the recordings. And so that can become tricky because it involves sending very large video files individually through email. It's time consuming and it can be a technological hassle. So internally we looked into it, and I suggested to the commission that we adopt something that the Judicial Council of Georgia does, which is to use YouTube. So we're now all YouTubers. During that meeting, there was a motion to allow that to happen. It passed, but also Dr. Tutterow asked me to look into the issue with the AG's office. So I did do that. I conversed and on a couple of occasions with Jason Ronis, our representative at the AG's office. And in asking 5 specific questions, and he provided a memo back to me. I'll just briefly go over that for everybody's information's sake. First, I said, does the Attorney General's office agree that recordings of the Child Support Commission meeting need to be provided to members of the public requesting such recordings if those recordings exist at the time of the request? And he concluded, yes. It seems, quoting him, it seems pretty clear that a recording of the public meeting would constitute a public record. Also noting there's several instances where exemptions are made within the statute itself of audio recordings and video recordings, thereby the narrative inference that they are presumed a public record and only exempt when specifically done so in the statute. The second question was if the commission opts to keep the recordings of its minutes beyond the approval of the minutes for that meeting, what is the proper retention period? And that's because per the state general records retention requirements, we're only required to keep the recording through approval of the minutes, but we keep them for our own purposes ongoingly. And the answer to that was to coordinate it with DHS, because for those who don't know, we are administratively attached to DHS. But staff is housed at the Judicial Council, and that's by contract, interagency contract. So I can get with you if you have any further opinion on that.
We can certainly review the DHS record retention schedule, and you can take your pick. You know, as to what you want to present as a recommendation. We can talk about all of them.
Perfect, exactly. My third question to Jason Nonis at the AG's office was, may the Child Support Commission use a YouTube channel similar to the one used by the Judicial Council of Georgia to efficiently and cost effectively provide video recordings of its meetings to the public? The response was he was not aware of any prohibition against the use of the YouTube channel, and he felt it was consistent with the intent of the Open Records Act, which is to make those all records available to the public. I then went on to ask whether the child noted that the Child Support Commission hears public comment at the end of all full commission meetings. Sometimes members of the public share personal details of their specific family or case. Does this fact affect the decision to post records of meetings publicly? He said, no, it's up to the public to decide if they wish to disclose confidential information, and that there's no expectation. Finally, I asked the Child Support Commission plans to announce at the start of each meeting and at the start of any public comment periods during the meeting that this meeting is being recorded and may be shared publicly for the Open Records Act. Is there any special wording needed for such an announcement? And basically, the long and the short of it was that he simply recommends that the commission announce at the start of each meeting that the meeting is being recorded and may be publicly shared. I further suggest that we do that a second time in case somebody hasn't caught that announcement at the very beginning of the meeting, to do it again just at the start of the public comment session. So my recommendations is that we start, we have Latana has created a YouTube channel for us. I think it would be a clean crossover to say all 2023 meetings will be on YouTube. That means we've got to go back and post the statute review meeting from February and April. And that means this meeting will go on YouTube. I do have a question. We have two options. We can live stream meetings that then get permanently archived and housed on YouTube until we decide to be able to. Or we simply add a video, upload a video to YouTube sort of immediately following the meeting. Does the commission have an opinion one way or the other, which they would prefer? Both, as most things in life do, have pros and cons. And
I submit that to commission members. Any comments? Commission members, any preference?
I didn't opt to live stream this meeting, even though you had approved it technically in December, because I didn't want to say surprise, we're live streaming immediately right now. But pro would be, it's an additional way for folks to join the meeting. We need Zoom credentials to be on the meeting. Con, it's a little bit more work on the front end. Also, I will let you know if something ever were to go awry with the live stream, that's out of our hands while the meeting is going on. The backup is always to then just upload the video immediately following the work,
Yeah, my view is that there's no direct benefit to the commission or the public that we know of. There's no reason for additional work on staff. So I would say that's what we had a problem also in the middle of a meeting when lose the stream. Some people expect us to stop the meeting until we get back live. So I would say not live stream, but anyone else have any thoughts? I don't think it's an action item. I'll just leave it up to staff then.
Okay. Then I think we will make it a regular practice to start using, we'll upload the 3 meetings that for 2023 thus far, and then going forward, it will mean every meeting, all subcommittee meetings. Sometimes our subcommittee meetings are actually more vibrant, shall we say, than our full commission meetings. So all meetings will then very shortly after the the meeting will be uploaded, those recordings will be uploaded to the YouTube.
And I do have a question about the credentialing though, just to log on for the meeting through Zoom. What credentials are you talking about? For the general
Just the
public?
webinar ID and the
Yeah.
password, but that's publicly provided on
Right.
the commission's website.
So I do have a question regarding that. So how long would the uploads remain on that YouTube channel? You said you were gonna upload some of the previous meetings as well as going into the future.
Indefinitely, I think.
Okay.
But we have made- And we could come up with a policy on when they get deleted, but I think things of this sort,
Mhm.
while the record exists, they remain subject to the Open Records Act. So it's bound up with the records retention policy.
Okay. Is there any concern in terms of like space with the YouTube? I don't think there is, but to be able to maintain those records.
I don't think there is, but that's something we can look into. I think it's there. It holds a lot of video, is my understanding. But I'll note that, we can look into it.
All right, thanks.
Thank you, Scott, for the question. So can I officially tell my grandkids I'm on YouTube?
We have arrived.
It's important.
YouTubers.
I hadn't thought about that, Judge. I'll tell my grandchildren the same.
It'd be cooler. Oh, cool. I'm sorry.
One more thing, you may find, folks are already taking it on themselves to post videos privately, like through YouTube. So you may find other videos of previous meetings on YouTube already. But so I do think another reason to go ahead and do this is that we would be the official record, the custodian of the recording, and then it would be permanently on YouTube for public access to see exactly what is transpired.
Thank you.
Thank you.
Senator Strickland cannot make the meeting today, so Judge Williford is going to submit that report.
All right, thank y'all. First, let me say that to our new commission member, Representative Evstration, I can remember being at my first commission meeting, and I don't know if this is your first meeting or just your first meeting as a member, but I thought, what are these folks doing? It just did not seem like we were getting much done. And what I have learned is that this is really just a report of everything that has been done through the subcommittee work. So the work really happens, as Judge Key says, in the subcommittees. So we welcome you and we beg you to be on the statute review subcommittee. The statute, and everybody thinks their subcommittee is the most important subcommittee. But I think the statute review subcommittee is where you belong, especially since you're in the legislature, obviously. And we rarely have a quorum at our statute review subcommittee. So we need some additional members, and we're doing some very important work on parenting time. So I'll just take that minute to put a plug in. And Elaine, if you will get his contact information for me, please, I would appreciate it. So
I do want to report to you that he's already asked me, could he be a member of the statute review?
Even before you're.
I'm back for no reason at all. You should have led with that, Elaine.
Wonderful. The pitch, and Katie might want to jump in too. Pitch as well. She's thumbs up.
We're a fun group. So Senator Strickland reached out to me, and he was very upset that he could not be here. He actually had to appear at a hearing in Butts County this morning, and said that if any way it got resolved or he could get out of it, he would jump on the call, but he hasn't jumped on. So he asked me if he was not able to jump on, if I would report for him, and I'm happy to do that. So as those of you know, we had asked for some study committee legislation and resolution was sent, and that didn't happen. It didn't make the final passage this session. Senator Strickland says there was no opposition to creating the study committee. He wanted to make that clear. It's not like he presented it and everybody said, no, we're not going to do that. It just simply was caught up in a heavy volume of bills. As you all know, this was a very busy legislative session. And so it just got caught up in all those bills and didn't get across the finish line on day 40. So the study committee would have created a formal committee to examine the issues that we want to explore concerning the parenting time deviations. But what he thought was important was that since he chairs the Senate Judiciary Committee, he could still call for a committee hearing to formally address the issue in the same way that a study committee operates. The difference would be that instead of having a study committee comprised of the experts we contemplated to study this matter, the entire Senate Judiciary Committee will be invited to the hearing. He said, that says I have the discretion to create any agenda we want to create and can avoid us having to wait another year to dive into this issue by calling a hearing and having the testimony we want presented on this topic. He says then, if the goal is to present this issue to the legislature, it may be more beneficial to call a Judiciary Committee hearing, since it is likely that this committee is the committee that any legislation may travel through regardless. If we want to do this, I can ask the chair of the Senate Children and Families Committee if she wants to join us in a joint hearing to get more senators in the room. If we want to pursue this, I just need someone to take the lead and come up with a list of who we want to invite to speak and what material we want covered. Typically, a hearing won't last longer than 2 hours, and we can always schedule a second hearing if we need to. So that is the report that Senator Strickland wanted me to share with the commission. I think based on what he's saying, it makes all the sense in the world to ask him to do that, and that we would need to then just move with coming up with what he says is someone to take the lead, and 2, to come up with a list of who we want to invite to speak and what material we want covered, so that he can come up with agenda and get a hearing scheduled. Judge Key?
As first, Representative Administration, do you have any thoughts on that as
Well,
we go?
Yeah, thank you, Judge. I think the chairman's idea is very well made, and I think that, often it can have the same outcome, or maybe even really get the decision makers in the room earlier on to have what we call an ad hoc subcommittee of the Judiciary Committee meet to discuss an issue, or the full Judiciary Committee just consider it. I also think that we have many great experts on the commission here. So many legislators are probably going to look to the commission members here for guidance as to what is best for issues like a parenting time deviation or other proposed modifications to the law. So those are my only comments. This just being my first meeting here today, but I look forward to talking with the other members of this subcommittee here and talking with Chairman Strickland about his thoughts further.
My thought around that, since you asked, Judge Williford, is that the logical people to take the lead on this would be you and Katie, and working with staff. So I don't think we need a formal vote to move forward with this. This is akin to what we'd asked to do to begin with. So I would say let's just develop a plan and go with it.
All right. Thank you, Judge.
Comments from anyone else or questions from anyone else? All right. Thank you, Judge, for your report. I guess legitimation next is me. So I do appreciate, Judge Williford, you pointing out that I have the easiest job on the entire commission because the work's not done in this body, it's done in committees, which is true. By design, it's done that way. So the issue of legitimation was talked about some in statute review last year for various reasons. And during this meeting, I actually texted Katie and asked if she would refresh our memories about the role legitimation plays, particularly in parenting time. So, and she said she would. Katie?
Thank you. Thank you, Judge. So a couple of things worth noting, and hopefully this isn't news to this committee, but just as a reminder, Georgia is in the minority of states in terms of how we handle legitimation. And at the Statute Review Committee, we sometimes talk about being on the good side of the minority, where you're on the front of change. And so you're in a minority, but you expect that eventually that will become the majority, versus being on sort of the bad side, if you will, of a minority, which is where, the rest of the country has made adjustments to their, be it child support guidelines or for this conversation and the way they handle legitimation. And unfortunately, Georgia is in the small minority, really needing to look at a change because we require, a full lawsuit, a judge's signature. There's, don't get me wrong, I'm a big fan of due process, but we make legitimation hard for Georgia families, especially when you consider, and Elaine always knows this number off the top of her head, but approaching 50% of Georgia's children are born out of wedlock right now, in the very high 40s. So, we are almost at 50% of children born in Georgia today are illegitimate, by definition from the time that they're born. And that means that this problem is growing. It's not getting smaller, and we make it very challenging to legitimate a child, and therefore we then have issues when it comes to addressing child support and what that should look like. Parenting time becomes an issue because we will have very two involved parents, but where one of whom does not have any legal rights to the child and therefore no legal responsibilities to the child. I think that flies in the face of Georgia public policy, where we want children to have two parents who are responsible for them both emotionally and financially. So I'd love to see Georgia make some change, joining the majority of our sister states, making legitimation easier, therefore making child support easier to address, parenting time easier to address, and really put Georgia's children in a better position than they're in currently for both financially and emotional support from their parents. I don't know if that's what you had in mind, Judge Key, when you texted me, but that's a quick summary.
Yes, thank you, Katie. And I'm interested in the issue of legitimation wearing different hats. Certainly from the Child Support Commission, but also as a juvenile court judge. And decisions that we make around legitimation will have impact on Division of Child Support Services and the work of this commission. So I think it's something we should be interested in and be paying attention to. I've been on the bench, just finished 34 years, and I'm still having parents come in as a father in a dependency case who has been paying child support for 9 years regularly under a child support order obtained through the Division of Child Support Services. They had no idea, they had no right to be sitting at the table, because under our current code, the putative father is not even a party to dependency action, has no right to notice of a dependency action. The Department of Family and Children's Services, DHS, I think does a really good job of engaging fathers, doing the best that they can, but they come in at an extreme disadvantage in so many different ways. The process when they come to juvenile court, they can file to legitimate in juvenile court. There's still some issues around whether, if the court enters an order for custody or visitation, anything beyond just legitimation, that survives the juvenile court jurisdiction. Judges differ in opinion about that. There's no case authority for it. But I think children and families would be better served in Georgia if it were easier to legitimate. My personal view, if I may share it, is that when we have a man and a woman who are the biological parents of a child, the government has no real business in whether or not they legitimate that child. Around issues of custody and visitation, certainly, and support, certainly. But we have intact families out of this 45% of Georgia's children between the period of 2018 and 2022 who are born out of wedlock. Some of those children live in intact families with both of those parents, and you wouldn't know the difference except maybe by some names. And so I think children are better served with an easier process. I was discussing this family treatment court between staffing and court, and a de facto supervisor says judges should be like getting a marriage license. I said, what do you mean? Well, people agree to go get married and have children together. So why can't it be that easy? Consenting parents who want to legitimate the relationship with the child on behalf of the father, why shouldn't it be that easy? So it has significant impact, certainly in juvenile court, where, as I said, currently a putative father is not even a party, and some of our judges, some of our courts do not give them notice of dependency proceedings because they're not a party. They have no right to notice. Termination of parental rights, yes, but not a dependency action. that they have no right to counsel. Some courts give them a party equivalent status. There's no real legal authority for that. But again, it's good for children and families when fathers and kin and kinship all come in from that side of the equation, if you will. Some of you may or may not know that last year under the MOU entered into between the Council of Juvenile Court Judges and the Department of Human Services, arising out of the contingency for the supplements and SAC pay, was created a child welfare law and practice work group. I happen to chair that. The co-chair is Lee Moss, a Special Assistant Attorney General out I-20 that way. Forget the county, who was co-chair appointed by the commissioner. And I wrote the operational guidelines for that work group and patterned it after this very body, where most of the work is done in committees and not in the full work group. Jerry Bruce chairs the legislative committee. Lee Moss chairs the practice committee, and Diana Rue Johnson chairs the data committee. I would like to see, I tend in some capacity to ask the legislative committee first to address this issue of legitimation. We have a diverse group of representatives in terms of what we do, our roles that we play in the system on the work group. The committees would be free to bring non-work group members in. We would involve obviously the Division of Child Support Services and Child Support Commission and anyone else. So we can talk about, have any discussion you want around it. What I'd like to do is get a sense of the group here as whether this is something you think the commission will want to be involved in some capacity, certainly represented on that legislative committee that looks at potential legislation. Questions or comments?
Judge, I just want to say, first of all, thank you for your leadership. And I know sometimes it seemed like just a voice in the wilderness talking about this over the last year or so, but it is something that I think resonates with the general public. And as a practical matter, it's an issue of fundamental fairness when you start talking about, it does relate to child support. I know there may be some philosophical discussion about, is this really relate to child support? And should the Child Support Commission be focused on this? But it's on one level, it's a fundamental fairness issue about someone whose paternity has been declared, is a child support obligation attaches to that, and they are a legal stranger to the child under the Georgia framework. And that really is the policy sort of matrix. If it were an easy discussion, however, and an easy lift in the General Assembly, not to go through the sordid history about this that Leader Abstration can weigh in on as well, but and we had to repeal administrative legitimation because it doesn't fit and it didn't work and it was a problem for all the reasons we've talked about. When we were doing the Bryan versus Ship fix and dealing with that legislation, it was clearly discussed, and if it were easy, it could be fixed. But if it is something the commission decides to take on, I did pull just sort of I'll call it an interactive document that from an online source that allows you just to click on the statute of each state and see which one works best. But the large majority of those states simply tie it to the paternity determination. If there's a paternity determination, then that's a legal father. And so it is an idea, I think, because of the number of children who are born out of wedlock whose time has come. And there's a very clear connection between the payment of child support and contact and connection that non-custodial parent has with a child. So whatever help I can give to bang that drum with you, I'm happy to, with or without the full support of the commission, in authorizing the subcommittee to do something. But in the meantime, in this last legislative session, the department did take the step of SB 135, which is being signed today by the governor, to make those genetic testing results self-authenticating in other civil actions, including legitimation actions in the meantime, as we work through this. So at least those non-custodial parents where that paternity has been declared will be able to use those test results and be one step closer to the legitimation action. So I appreciate your efforts.
Regina, anyone else?
Yeah, thank you, Judge. Regina, I remember you worked very hard on that legislation to repeal the administrative legitimation. I
The
believe.
juvenile, it came from the juvenile court judge.
Absolutely. I guess I was just curious, what were the, because I don't remember at the time, what were the concerns that that would prevent us from correcting that process or addressing how it fit into the statute as opposed to repeal?
As sort of, I think that it was either the Court of Appeals or Supreme Court then reminded everyone that later that as long as you've got the legitimation statute in place, you can't do anything administratively that doesn't use a judge as a gatekeeper. That's 38,000 foot. But you can't have the legitimation statute and let a hospital personnel administer a form that declares legal status in that way. And so they can't admit paternity because but as the best interest of the child analysis, only the judge is a gatekeeper there.
Well, not to jump too far ahead then, but is it really to implement, I guess, what you're talking about here for just, as is done in other states, once paternity is established, then, those legal rights are there. Is the idea to just effectively do away with a legitimation
You would have to.
standard, and then you could really reinstate what effectively was done with an administrative legitimation previously. Is that right?
You still, I think, that even the administrative paternity, help me here, Katie, or anybody else, Judge Williford, who studied this more, but even the administrative declaration of paternity is still subject to needing a judicial order to declare that before a child support obligation is created. So it's that process where the paternity is declared by decree, that then it's a one-stop shop, for lack of a better word, to create the child support obligation as well as the legal steps.
But it would still require the filing of a suit if that was the basis with which administrative legitimation was repealed.
That's correct.
Well,
Depends what the law
But not
says at the
to-
time. Depends what the law says at the time. There were problems with administrative legitimation, a number of them. Surprisingly, what we found was on the form for administrative legitimation, there were two spots to sign, one about 2/3 of the way down the page, which was the acknowledgement of paternity, and the legitimation at the bottom. Only about 60% of the fathers, I put in quotation marks, who signed the top for acknowledgement, signed with administrative legitimation. We don't really know why, but that was what we found when we reviewed the data, we reviewed the forms. What we had also is the guy who loves mom to death, but he actually just met mom 3 months ago, and he was legitimating as a child. There's no DNA component in that process. And I have, again, we don't have a lot of time to spend on this today, but I actually have an outline draft of what I think it would be good to look at, just a discussion draft to start it. Under my proposal, it would not eliminate judicial legitimations in court like they are now. It would be a step before that, because we're going to have those where they are contested. We're going to have those where the mother will not consent. We're going to have those where it may not be in the child's best interest. When someone raises the question, are those where the father has lost his opportunity rights, which is what the court would have to decide. But in those cases, this is primarily those cases where the parents agree and consent. You have consenting biological parents of the child with the DNA test. This standard prove that father is the father, and the mother would have to attest under oath also that she knows of no other person claiming to be the father of the child. And it would be a certificate process. So you get a certificate of legitimation issued by a court of competent jurisdiction, whichever one that may be, whether it's the juvenile court, we already have jurisdiction to do legitimations, whether it's the probate court or whether it's the superior court. And it's just for those situations where the parents consent, and we're making them go spend money to do something that shouldn't have to be done. Because it's a huge barrier. I mean, back when I practiced law, minimum $1,500 a minimum, I would do one for, and that would generally be uncontested.
seem to remember during the debate also there was an issue as to the records after the fact, accessibility of the records with the administrative legitimations issues with that. This would address that as well. So that's good to hear.
It would, as a judge, what I would like to see also at Vital Records is to have a registry where all legitimations are filed. So when I'm trying a case and this child was born in North Georgia somewhere, nobody knows if the child's even legitimate or not. The department doesn't know. If they don't know, it's got a last name. The department normally alleges that in pendency petition alleges that the father's putative because they don't know that he's not. They just know they were not married, but they don't know if the child was illegitimated. And oftentimes the father sitting in that courtroom who's paying child support regularly, visiting with the child, has a relationship with the child, says, sure, I legitimated. When I started paying child support, I legitimated. Well, he didn't. And also this affects the division of child support services because that would be the perfect spot to be able to do this very easily. Regina mentioned basic fairness, and we do have the state involved in imposing child support obligations on fathers, but no one helps the father establish his legal right to the child. Would not deal with custody visitation. That would have to be done some other way. This is just for those parents who consent and have their business worked out. They don't need the government getting involved in it beyond just that. So if there's interest in the, I just want to make you guys aware of it. I think it's going to wind up in any event with this, with the work group and the legislative committee of that work group. And so if there's any sense that we need to be involved in those discussions as a commission, which would normally probably go through a statute review committee, or was any opposition to it, certainly opposition to the commission being involved. Anyone want to speak further?
Judge Key, if I may, first of all, Katie says we're in the minority. My understanding is we're in the super minority. Isn't it Georgia and maybe Mississippi that still has this antiquated law? Maybe just us and one other state maybe has this legitimation issue. And I can't really say without further thought if this falls within the purview of the Child Support Commission or what anyone else thinks about that. But I will say that this certainly has become an issue in the fix with the parenting time issue. So the parenting time issue that we've worked so hard on, and I say we, Katie and her committee worked on it for years before I even got involved in it. Trying to figure out, is this going to be a deviation? Is this going to be an adjustment, and how best to implement that and make that work? One of the roadblocks, I guess, that we keep running into is that because of Georgia's legitimation issue, I'm going to call it, there are certain fixes that we cannot consider, and they may be the easiest and the best fixes, but we can't consider those fixes because of the way that 46% or so of children are born out of wedlock. So it has become an issue for this commission in our statute review subcommittee work when we're discussing potential fixes to a problem. We say, oh yeah, but what about this legitimation issue? So as it relates to child support, I can chime in there and say that has been an issue that has come up.
Thank you, Judge Wilson. Any other comments, questions? All right, thank you all. So let's go next to back to Noelle with status of HB 499.
Yes, thank you, Judge B. Just briefly on this, really, it's an agenda item to keep it on our radar. This is a bill that popped up mid-legislative session, just this past session. The commission was not previously aware of it, but it did dramatically affect the child support guidelines by proposing to extend the duration of support for what that amendment termed a disabled child, so that a child declared disabled would receive child support beyond the age of majority. And we discussed this briefly during the February statute review subcommittee. We were not asked to comment on it by the filers of the bill, and it ultimately was sent back to committee and did not cross over. But we just want to keep this on the commission website, keep it on the commission's radar because it could certainly come up again next legislative session. I want to note that we did attempt to schedule speakers for today's meeting to discuss the impact that payment of child support could have on government financial assistance. Unfortunately, those speakers that we invited had conflicts with today and could not attend. Those speakers were from the Social Security Administration and Medicaid, and they've been asked to participate in August 11th meeting. So we will, and we also, Elaine in particular, plans to invite the sponsors of that bill to also attend on August 11th, so there can be a full discussion of the matter. And that's all, really, it's just a point of information.
Questions or comments? We'll be talking about that in August. Thank you, Noelle. So Elaine, commission membership.
Okay, thank you, Judge. Right now, one of the things that I do is monitor our members of the Child Support Commission, for executive orders to make sure that we know when members are, when their terms are up, when they need to be reappointed and so forth, legislative members as well. And we are right now in the process of looking at, there's my email. We have, is it 7? Sorry, we have 7 members whose terms will end on July 1st of this year. That would be Judge Key, Chuck Clay, Katie Connell, Judge Jones, Lisa Jones, Regina Quick, and Christina Scott and Dr. Roger Tutterow. I've communicated with each one of those members and they want to be reappointed to the commission. We thank you for that. And I have already notified Amy Doerman in the governor's office who handles those appointments, and they are working on those reappointments for those 7 members. And yesterday I received an email from Amy and providing to me the executive orders for the 4 legislative members, including our newly sworn in member, Representative Evstration. So I have those orders, those terms all expire January 13, 2025. So that's something that we'll be monitoring, and we are appreciative of the governor's office doing that for us. And so this, with the appointment of Representative Evstration to the commission, that fills that 4th legislative seat that's required under statute. And so we're back up at full strength of 15 members of the commission. And we also want to encourage, and I'm afraid that I laid down mine. Thank you so much. She reads my mind. We have a roster, if you will, of the members that serve on the subcommittees. We have the Economic Subcommittee, the Technology and Calculator Subcommittee, and the Statute Review Subcommittee. And I know that Christina Scott, a member of the commission who has been serving on the Economic Subcommittee, has asked to be removed from that subcommittee, but she wants to continue to serve on the Statute Review Subcommittee. So that's one of the changes that we'll be making. And on our Economic Subcommittee, if anyone wants to serve with Dr. Tutterow, if you would let him know, that would be great. Right now we have Chuck Clay serving and Representative Houston Gaines. And then we have 3 non-commission members, but of the commission members, that's who I'm discussing today. For Regina Quick, who's chair of the Technology and Calculator Subcommittee, it's herself and Senator Emanuel Jones. So if any of the members want to serve with her, please approach her about that. She might want to be fortified with some additional commission members. And then we know that today Representative Evstration has asked to be a member of the Statute Review Subcommittee. And that would bring our commission, let me just double check. That would bring our commission membership for statute review. Is that 10? Am I counting that correctly? 5. Yes, that would bring us up to 11 members of the commission itself serving out of the 15 serving on the Statute Review Subcommittee. And then we have some non-members also serving who we greatly appreciate their contributions. Former Representative Bonnie Rich, whose position, Representative Evstration, you're filling, she asked to continue to serve on the Technology and Calculator Subcommittee, and we're pleased that as an attorney, she will continue to serve with that group. So I wanted to make sure that everyone was aware that we monitor, all the members are aware that we monitor their membership, and we make those contacts. I tried, when I'm looking at members whose terms are going to expire, I try about 6 months out to start the process of getting the reappointments in place. I know the first year of the governor's new term or the first year of the governor's second term, in that first year, the appointments come a little bit slowly because there's a lot that the governor is doing to reappoint people to different committees and so forth, commissions. So it takes us a little bit of time, but what is required is that if for any reason your term expires, it's July 2nd and your term on paper has expired, you are required to continue to serve until your position is filled. But we know that out of the 7 that I just mentioned a moment ago, that I've written to the governor's office about the reappointments of those existing members, those will come through. They're working on them, and so just a matter of time before we'll receive those. And that was all I wanted to report. Are there any questions on the memberships? The appointments?
Just by way of information, and if reappointed by the governor this next term, it'd be my expectation that at the end of next year, I would give the governor the opportunity to appoint a new chair because I'll be leaving the full-time bench. And I think we need a full-time person sitting here. I hope to continue some senior judge work if I can, but I'll be leaving the full-time bench. I'll give the governor that opportunity. So although I'm hoping for a 4-year term, a reappointment, I would intend to stay this year next. I really would like to be able to stay until we get the parenting time through the legislature. So we'll have to get that done next year. I'd like for that to be there when I leave. I was here when the original child support bill was passed and it was in there initially. And then we did the next year, and the next year the legislature took it out because we couldn't define what a day meant. So just for information, that's my plan.
Okay.
Anything else?
Thank you, Judge. And when we do get the oath of office and your executive orders for those 7 reappointments, we'll work out to do a Zoom call with you so that we can take care of that all at one time for swearing in. The governor's office allows Judge Key to do those swearing in, except you can't swear yourself in. So we'll have to figure that one out. But we'll make sure we handle that. And I see that Representative Gaines is having to step away from the meeting.
All right. Thank you for being here, Representative Gaines.
And that was everything for me.
So we'll move next to the public comment section. You want to give the YouTube speech real quick for someone before we start public comment?
Yes, so we are about to start public comments. This meeting is being recorded and will be shared publicly by YouTube going forward, so please note that. Also, if you wish to make a public comment, please put your name in the chat. I know we have one previously scheduled, but then if there are any other folks wanting to make a public comment, please type your name now in the chat section.
All right, we have a timer set up.
Okay, and Latana, are you bringing over Mr. Raja Antone, who wants to make a public comment and address the commission? He asked for 10 minutes to speak to the commission this morning.
Is he on?
Yes, sir. She's promoting him now.
And I am, with all apologies, we're running a little bit over. So if you don't mind, sir, I'm gonna give you 8 minutes instead of 10. And let me know when you're ready. And thank you for being here. You're welcome to make your comments to the commission. I'll start the timer when you start speaking.
Hey there. Good morning. Thank you very much. 8 minutes should work, Judge. Thank you. And I'd like to say I'd be remiss if I didn't say I enjoyed your comments a moment ago about legitimation. That was refreshing. So I don't know if Latana or Elaine has the PowerPoint that we talked about. If you check your email, you would have it. You can disseminate it later. I do have it on my laptop, and I'll just go through it with as much brevity as possible.
Sir, I would ask if you're going to speak to the commission that you show yourself.
Okay. I didn't. I saw my thumbnail. I didn't. There we go. All right. There we go. Thank you very much. So my name is Raja Antone. I am the founder of the 501c3 called the Lead Off Foundation. And within the Lead Off Foundation, there's a pillar called the F6 Initiative. And F6 stands for Fight for Fathers, Fight for Fairness. It's not just about fathers, it's about parental equality, but we certainly have a focus on fathers' rights. I'm previously divorced and remarried, father of 2 sons. The Lead Off Foundation, or the F6 Initiative, is centered on advocacy for, as I mentioned, parental equality and fathers' rights. committed to the pursuit of revising legislation, revising narratives and perceptions of non-custodial parents. I'll skip one of my slides that I sent over to Latana and Elaine. I'll just go into some of the key points I wanted to touch on here. It's about regarding child support. We believe that, and let me put a pin here. Over the last year or so, we did 12 months of somewhat of a podcast, and what we did was we had various persons, from attorneys to fathers to mothers, come in and speak about various topics. And so the data that we captured was really an amalgam, right? An amalgamation of all of the experiences and our research that we've incurred and encountered. We think that from the start, excuse me, the child support worksheet really needs to be recalibrated. The tenor is more punitive than provision in scope. I was listening to Elaine talk a moment ago, and Elaine and Latana and Noelle absolutely love those ladies. But I just wanted to call out about the worksheet. It's focused more on, if you think about the data that we just heard, it's focused more on how the imperfections or the errors made, how there's a lack of adroitness by the submitter, more so than the need. Is focused more on the income and the errors made by the submitter, more so than the need. And I think we need to focus more. We need to recalibrate the tenor of the worksheet, because it feels so invasive and pervasive to the submitter that it, from the jump, it sets a bad tone for those who are involved. We think that the child support worksheet, if you look at online, if you were to go to online and pull up the child support calculator, almost immediately after you put in your demographical information, your personal identifying information, it automatically immediately goes into income, and that sets a bad tone. We also feel that that non-custodial parents are penalized for success. Fathers don't commonly see decreases in child support when their mothers, when the custodial parents' incomes increase. And when we do go for a downward modification, the timeliness, the guidelines, the costs associated with that, it's really, really hard to get your arms around that. So you're constantly suffering with the prospect of having some relief, even though in the present, you're constantly suffering. So there's no relief. And we like to see that become more efficient. Then there's the element of the high wage earner impact. Sure, we talked about the low income deviation, but there's also, on the opposite end of the spectrum, there's the high wage earner dynamic. And so we would like for there to be some concern, some interest, some focus put on that. And then lastly, fathers don't ever see their 1/3 of the child support award that stems from the order. We talk about, if you look at it, it's usually 66% to 33%. Fathers never see that 33%. The next thing I'd like to talk to with the time left is we understand that there are federal guidelines involved, but it would be wonderful if in our state, if there would be a way for Georgia to allow for non-custodial parents to receive some relief at tax time. We're constantly paying child support throughout the year, and we're carrying the burden financially for those children, but there's no relief. Child tax credit, whatever, Biden bucks, whatever you want to call it. Fathers non-custodial parents never really get to quote unquote write off or claim that child as a dependent. And we'd like to have some way of being able to recoup or assuage the albatross that is child support. The other thing is about paying child support during the summer. We really feel like that's a matter of double jeopardy. If we understand the need to maintain a household for the custodial parent, but the non-custodial parent has those same needs, has those same responsibilities. And so that non-custodial parent oftentimes has to make a decision whether they are going to risk it, so to speak, and not pay the child support, or risk it and forego time with that child, because oftentimes you can't do both. And then there's the gestational pregnancy implications that are especially on front stage as a result of the Georgia anti-abortion law. So we'd like to really weave that into the discussions a little bit more. As I kind of land the plane here, just talking about some of the long-term impacts, and you talked about them, and you kind of mentioned that in legitimation, Judge. You know, these long-term impacts, the albatross of child support, sometimes it's a deterrent to remarriage. You were talking about family, the family structure. You know, when it becomes so burdensome and overbearing, many parents, the deterioration of the family is in large part due to fear that the non-custodial parents encumber because of what they've witnessed, what they've had to deal with from the system, legislation, the courts, as it relates to child support. And if you throw alimony on top of that, then that's a whole nother ballgame. Then there's a perception, right? And you kind of spoke to this, Judge. Again, this is why we're glad to hear you say this. Society looks at the family, this productivity of the family, primarily based on the involvement and the engagement of those fathers, those non-custodial parents. And so when you don't have the resources and when you don't have the access to the children based on those constraints, and I'll get to one of them here, it really becomes burdensome. And lastly, I'd just like to point out here, I don't know, I may be up against it, but you know, we also pointed out current state versus future state. I'm sure Elaine and Latana can share that with you. But one thing it was good to see, and this goes back to the punitive nature of it, we were happy to hear about House Bill 167. I had a close friend who was working on that. And it speaks to the recidivistic nature of this cycle, this vicious cycle of paying child support, not being able to pay child support. You know, if you don't have a driver's license, you can't get a job, or you can't drive, you can't go to work, you can't go to work, you can't make money, you can't pay child support, you go to jail, and it just becomes a cycle. So we were very happy to hear about the auspices or the auspicious potential of House Bill 167 as it relates to getting that permit, because it's going to really bode well for those non-custodial parents, namely those fathers. So again, I just want us to look at the recidivistic nature of child support and some of the things that it does and the tenor that it sets from the onset with that child support worksheet. As I close, I just like to say that we are encouraged by what we're hearing at a macro level from this committee and the subcommittees, but we think that there is so much more to do, and we've outlined some of that in our PowerPoint. And just thank you for the continued work that you're doing, the light that you're shining on this matter, and we're happy to be a pillar of resource, research, and just thought as you move forward in trying to fix this albatross that impacts so many families. Thank you, and I yield.
Thank you, Mr. Antoni. Staff did not receive your PowerPoint. If you will send it, we will send it out to the membership.
Okay, I did send it. I was in sorry for the delay. I sent it last night. I was in a fatal accident. I was in an accident where there was a fatality, and I've been dealing with a lot of physical therapy and police and insurance. And so I sent it last evening, which was later than I anticipated. But if you, Elaine and Latana, if you check your email, you'll have it, and I'll send it again.
Latana, do we have anyone signed up to speak?
No, not.
Does anyone else want to make public comment? We'll give you 2 minutes.
Thank you, everyone.
Thank you all for your attendance, even those who did not make a comment. We appreciate your interest in the work of the commission. Before I close this out, anything, commission members, anything you want to say? Again, welcome, sir, to the commission. Thank you for signing up for committee work. They will put you right to work, I'm absolutely certain. And Judge Lagueux, we look forward to spending the time with you that we can. And thank you for your service to the commission. Our next meeting is August 11th at 10 a.m. It will also be a hybrid meeting, although I encourage you to come to Atlanta. It's a beautiful center. I don't know if commission members who show in person next time, we might could arrange a quick tour of the Nathan Field Judicial Center. That would be great. So is there a motion to adjourn?
So moved.
Second. All in favor, say aye.
Aye.
All say abstain, say nay. We're adjourned. Thank you all.
Thank you.